Marshall Chriswell is with us this morning. It's another installment of Martial Law. This radio program intended for informational purposes only. It does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending upon the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction. There's one of those right across the microphone from me right now, and that is Marshall Chriswell. Good morning.
Good morning. Happy Monday.
Hey, you and I were just having a conversation, and you said two things that piqued my interest. Number one, I was giving, how did you put it? I was giving a talk before a group the other day. We'll get into what that topic was. But is that something that you do a lot? Is you go out before groups and talk to them about, in this case, estate planning or some other legal issues? Do you do that?
I do. I've had occasion to be invited usually by financial planners, accountants, other professionals that have clients who, they realize that their clients could benefit from estate planning work.
Mm-hmm.
That's usually what it is, estate planning. And so they bring me in to give a presentation to their clients regarding that issue, and to impress upon them, give them the basics of what to expect and what they might need, and impress upon them the importance of having an estate plan in place.
Oh, okay. So those of you who have organizations such as that you think Mr. Chriswell might be a great benefit for your clientele, by all means, give him a call. He can tell you if he can schedule it or not. Right?
Absolutely.
All right, very good. Now, estate planning itself, and we were talking about executors and some of the criteria that you need to consider, and other things that you might want to think about before naming your executor of your will, and as you plan your estate. And one of the things you talked about was a primary executor versus an alternate executor. Is that a way to put it?
Right, sure. And this stemmed from a question that a woman asked me at that very presentation. She said, I have, and I can't remember, but let's just say she has 3 daughters. And she said, should I make my 3 daughters the co-executor of my will? And I said, well, certainly you can. The law says you can basically appoint anybody that you want as your executor, and you can have them serve in a joint capacity or in an individual separate capacity. So, you can do that. The question is, how good of an idea is that?
Okay.
So, and in some instances, it's a very good idea. But by and large, my advice to clients has been that you should pick one to serve as the primary executor, and then in the event that in this case, that daughter is unable or unwilling to serve, or it's too inconvenient for her to serve because she's far away or other reasons, then it would go down the line to the next daughter and then the next daughter. So it would be an alternate or contingent situation rather than a joint executor arrangement. And the reason for that is a couple of things. Number one, executors that are serving jointly, usually entities like banks and things, would require all of them to be signing checks. And other legal documents and decisions. They're all going to have to be present and signing those things together, which can be really inconvenient. The other thing is, and it goes hand in hand with that, is the fact that they're all going to have to make decisions together. And they're all going to have to agree and come to a consensus on every single issue. And no matter how well you get along with your siblings,
something can come up.
There are always situations where you're going to disagree. And so what happens whenever the co-executors, the joint executors, can't agree on something? Then they've got to go to a court, and they've got to ask the judge. And asking the judge can be expensive, because you've got to file a motion, and you've got to have a hearing and have witnesses and all these kinds of things. And we've talked before, Todd, about one of the biggest reasons that you put an estate plan into place your will and your power, certainly your powers of attorney and healthcare powers of attorney. All of that is done with an eye towards, with a goal of eliminating court action, not having to go to court. So if you have a situation where you have 3 executors that have to agree, or even 2 executors that have to agree on everything, there's a chance that there's going to be an issue that they disagree on, and they're going to end up at the courthouse anyway.
Yeah. You're right, though. And there's conflict in every, potential conflict in every situation when it comes to something that is so emotional. And that's one of the things that I think that we fail to recognize is there's a lot of emotion involved in a decision when it comes to executing the various aspects of a will. And removing the emotion from it and just making the correct decision can sometimes be problematic.
Well, we see it all the time with, you think that it should be, this is a purely financial decision, whether, a practical financial decision, whether to liquidate mom's assets, whether to sell the house and her personal effects and divide it equally among the beneficiaries, or what happened, or some other arrangement. And a lot of times emotion really comes into play because one or more of the children just can't bear the thought of selling the family home. Sure. or getting rid of some of mom's possessions that they really associate with her in a sentimental way. Mm-hmm. So yeah, absolutely. And estate planning, one of the benefits, one of the big benefits of estate planning is that you get to try to minimize those family conflicts. And you can never eliminate them. Yeah. But you get to try to minimize those family conflicts, and proper estate planning can do that. But there is always going to be the potential, and when you have executors that are serving jointly, there's more of a potential for that. Whereas if you appoint one of them to be the decider, so to speak, then that makes it a little easier.
Marshall Chriswell with us. The installment is Martial Law here this morning on Indiana in the Morning, AM 1160 WCCS and 101.1 FM. Something else that you said a couple of moments ago as well has to do with the necessity to be sure that your will is up to date and revisiting it because you might set your will in a certain year and name the executors. Circumstances change in everybody's life, and your primary executor might have moved or even passed away themselves, and just keeping everything up to date is really going to be to your benefit as well.
Right, yeah. And so estate planning is, it's not a one-time thing. That initial step, getting a consultation and putting together your estate plan and getting it signed and getting the peace of mind that comes with all that is important. But estate planning is a process, and you want to have a relationship with your estate planning attorney so that you can return to them and throughout your life, because circumstances change in all everybody's circumstances change all the time, and every aspect of your estate planning has the potential to change. And certainly when you're appointing people, executors and agents under your power of attorney, all kinds of things can change. Family relationships change. If this is a friend that you've appointed, perhaps you have a falling out. People pass away. People move across the country. So there are all kinds of things that should cause you to revisit your estate plan. And what we do at my office is every year we send a letter out saying, here's kind of a list of things that may trigger a change to your estate plan. And if any of these things have happened, or if you have any questions, you should call me and set up a time to come in and talk about that. So we're constantly trying to stay on top of that and remind people that this is a process.
Taking that initial step of estate planning is, for some reason, kind of difficult for people to do. What sort of response do you get when you send out that update letter? I would assume that since they took that first step, that now that they're into the system and they realize the importance of it, that they automatically respond. But that's probably not the case.
No. And I think most people, I don't know, a lot of people get it, and this is fine. They look at it and they say, yeah, everything's pretty much the same this year. I haven't gotten married, haven't gotten divorced, haven't started a business, haven't done these things, and they throw it away or they put it in their estate planning file and don't think about it again. But that 1 year when it comes and something has changed, then usually people call and they're pretty grateful that they received it, because they say, hey, I have my will that we did 5 years ago, and it's sitting in my desk drawer, and I never even thought about it. Whenever my daughter passed away, or I got married, or whatever it is.
Yeah, you're right. Once they understand from reading down through that list that you send them of things that could affect their will, that probably kicks something in, and they say, "Oh, I better get that done right away."
Right. Yeah.
All right. So there you go, boys and girls. That's the forewarning for you to make sure that your estate planning is underway. And to understand that it's not a final step in the process, it's the first step in the process.
It is. It is a process, and and that's something that another thing that I address with people is, should you go online and should you do your wills and things online and go to LegalZoom or one of their competitors and do it that way. There are lots of downsides to doing that, but one of the biggest downsides is you don't develop a relationship with somebody that knows you, cares about you, and wants to make sure that things are in place properly and guide you through that process we're talking about.
They don't know your name; they know your account number.
Right.
All right. So, if someone wants to get in touch with Marshall Chriswell, what must they do?
Go online to westernpalawyer.com. Call 465-5826 or stop in and see us in the Atrium Building in downtown Indiana.
Thank you, sir.
Thanks.
It is Indiana in the Morning, presented by First Commonwealth Bank here on AM 1160 WCCS and 101.1 FM.